Next up is Dr. Marja Lehto. She's the senior expert and ambassador of cybersecurity at the Finnish Ministry of Foreign Affairs, and she will be also representing Finland in the next UNGG process.
Thank you very much, and good afternoon to everybody also on my behalf. I would like to thank the organizers for having invited me to participate in this very interesting panel, and I also wish to commend Professor Schmidt and Dr. Matzak, who have made their case very convincingly. And at the outset, I should say that I recognize and share some of your frustration. Reported state practice and expressions of Opinio Juris are not always readily available. The UN International Law Commission, for instance, would welcome more responses to its questionnaires that are regularly sent to all member states with not so much results. And to add a personal recollection, in 2003, Finland made a pledge together with Sweden and Switzerland at the International Conference of the Red Cross, committing to promote international discussions on the applicability of international humanitarian law in cyberspace, or actually what the term we then used was computer network attacks. There was a conference the following year in Sweden and a book, but not much further follow-up, because the general feeling was that the topic was not ripe for further consideration. So I know what you are talking about, and I agree that states could be more forthcoming in articulating their views. And since Professor Schmidt mentioned Finland, I would like to flag this little booklet. It's a publication of the Ministry of Foreign Affairs, commentary to the Foreign Affairs Committee of Parliament on legal grounds for the use of force in international relations. It came out in December last year, and it includes a specific chapter on hybrid and cyber threats. And I will give a copy to you. Here you are. Okay, but having said this, I do have a few comments on what was presented as the silence of states, on the contribution of non-state actors to international lawmaking, and finally, on the risk or creation of a power vacuum. First, why have states been reluctant to agree on a comprehensive regulation on cybersecurity? Let me point out, first of all, that it may be misleading to speak of states as a collective unitary actor. States have different interests, and as I try to show, major actors in the UN discussions on the applicability of international law to cyber activities have pursued very different agendas over time. As you may know, the issue of information security has been on the UN agenda since 1998. But from the beginning, the discussions were challenged by the fact that the participants had fundamentally different approaches to the topic, including and in particular as regards the need for new international legal regulation. A proposal for an international convention on information security was in fact put forward at the UN. But as it was seen to promote a particular policy agenda, it remained isolated and has not been subject to further consideration. More specifically, this proposal was seen to go against the freedom of expression. It was not seen as quite compatible with the principle of universal and free internet or respect for human rights. In that situation, many states were happy to maintain that existing international law, including the law of armed conflict, is applicable to cyber activities. Another example, the denial of the applicability of international humanitarian law. And you still hear this argument from time to time, that international humanitarian law does not apply in cyberspace. This argument has very usefully served to underscore the case for a new convention to regulate the development of civilian and military technology, information technology, and additionally to convey the message that cyberspace should be reserved for peaceful purposes. So rather than being a result of ignorance or sleepwalking, it has served a specific, a particular policy agenda. But it's true that there's very little in the way of legal clarifications that the long UN process since the late 1990s has produced. But what I would like to stress is that this situation is in no way unique. The development of international legal frameworks in response to technological development is not always straightforward. And Kubo Machak already picked up a few examples. Sometimes it takes more time, sometimes less, to establish specific treaty regimes. For instance, the creation of a fairly comprehensive system of international environmental law has taken nearly 40 years. The ideal, from the point of view of legal security, would be a comprehensive, international, preferably UN-backed convention binding on all states. As a close equivalent to this, the UN Convention on the Law of the Sea took 8 years to negotiate and another 14 years to enter into force. And on top of that, the UNCLOS drew on no less than 4 earlier conventions, as well as on centuries of state practice. As for cyber activities of states, there's yet no treaty regime and no agreement on the need to go down that road. Embarking on negotiations on a multilateral convention in a situation in which there's no common understanding of the scope or the purpose of the exercise would not be advisable. It could lead to a protracted process that could easily become subject to political hijacking. Against this background, the agreement in the UN Group of Governmental Experts in 2013 on the applicability of international law in cyberspace can indeed be seen as a breakthrough. And the list of norms of responsible state behavior of 2015 as another step forward. From the Finnish point of view, I can say that we fully agree with President Obama in that development of norms for state conduct in cyberspace does not require reinventing of international law, nor does it render existing international norms obsolete. However, while the general rules and principles of international law are applicable, they do not give answers to all practical problems that states confront with regard to hostile cyber activities. It could therefore be useful at some point of time to elaborate a few more specific rules, taking into account the characteristics of cyberspace and cyber activities. It could also be useful to clarify how other areas of law apply to cyber activities. International law is a system of closely interrelated rules. There's no activity that would be regulated only by the specific rules designed for it. For instance, human rights obligations apply across the board. We have therefore welcomed the work conducted at the invitation of the NATO CCD COE, which resulted in 2013 in the publication of the Tallinn Manual. And we are looking forward to the new and expanded edition of the manual, which is due to come out at the end of the year. The first edition of the Tallinn Manual has been an extremely useful contribution to the discussion of cybersecurity. Compared to the CGE list of norms, it's much more specific, going into the substance of all essential rules that govern the use of armed force by states and the laws of armed conflict, as well as certain other questions. The Tallinn Manual is unique as a restatement of international law applicable to cyber activities, and it has already been influential. At the same time, it's not rare that non-governmental entities contribute to international lawmaking. Non-state actors often bring issues to the international agenda, make recommendations, propose specific wording, or even present draft conventions. And this is nothing new. Early examples include the 1948 Genocide Convention that was advocated by one individual, the 1984 Torture Convention that was proposed by Amnesty International, and the 1996 Convention on Non-Navigational Uses of International Watercourses, based on the International Law Association's Helsinki rules. More recently, the conventions to ban landmines and cluster weapons were already mentioned, and I should add that NGOs contributed hugely to the drafting and adoption of the Rome Statute of the International Criminal Court. I quote Bowl and Shinkin, who wrote already in 2005, "We now have a proliferation of institutional and non-institutional actors working within the international legal arena. The body of reports, expert opinions, guidelines, and studies produced by these actors is immense. The multiplication of actors in international lawmaking is a fact and has been a fact for a long time already. And this is why I don't see the situation in as dramatic terms as has been presented here. And I don't think that it should be described in terms of a power shift, power struggle, or a power vacuum. States still retain a unique place in international lawmaking, but they don't have exclusive control over it. A broader development has been going on for some time, and I believe that it has been beneficial to states, to non-state actors, and at the end, to international law. The work of independent experts, such as the Tallinn Manual, can be valuable and influential. The same goes for some other scholarly contributions, and Professor Schmidt already mentioned that teachings of the most highly qualified publicists in international law have been mentioned in Article 38.1 of the ICJ statute as a subsidiary means for the determination of rules of law. Customary law cannot, however, be based solely on scholarly writings. In that sense, and in formal terms, the question is not about non-state actors taking over. Whether inaction of states has legal implications is a question that has to be approached very cautiously and requires a careful analysis. In conclusion, states have formally the last word in the creation of international law, but the lawmaking process can only profit from the fact that there are different contributions to it. The complex interaction between different participants in international legal arenas should not be described in terms of a zero-sum game. For me, it's rather a win-win situation. I would like to stress that all the bits and pieces of normative work under the UN auspices or between interested states or individual experts contribute to clarifying the law applicable to cyber activities, create shared expectations, and in that sense also pave the way for more specific regulations in the future. Thank you for your attention.
Thank you, Marja. I have a present for you as well. Enjoy. Now, thank you all three for very interesting presentations, and I'm opening the round of discussions. I have some questions of myself, but please get ready to ask. One of my first questions, which is very interesting, is mostly for Mike. Regarding the process at The Hague, and that was one of the first times during the Tallinn 2 process where states could give input to your work. Could you comment on this and give us some more insights, whether there were some certain areas that they really agreed on, where there was some very areas that did not have consent at all, or...
Well, let me place it's a good question. Let me place the question in context. During the first Tallinn manual process, states held us at arm's length because, frankly, they didn't know what we'd come up with. And the last thing they wanted was to be trapped by association with these 20 people who were trying to figure out what the law was with regard to armed conflict. So they held us at arm's length. Although I will tell you that a number of states were active behind the scenes in providing us input, it was all at arm's length. However, the Tallinn manual hit the streets, and as the ambassador said, it seemed to be a rather a success. I mean, it's on the desk of most of the legal advisors. If you're a legal advisor, I suspect you have a copy. So when Tallinn 2 came around, states were very interested in participating this time because they knew that legal advisors around the world are going to have this book on their desk, and they wanted to have some input into the project, albeit in a very informal way, non-attribution way. So the Dutch government, God bless the Dutch Ministry of Foreign Affairs put together a process called the Hague process that I mentioned in my presentation that brought together 50 states, including all of the P5, for a series of meetings in the Hague. There were 3 meetings. At the meetings, a number of us, Lies Vihul is in the audience, our project manager, myself, some others who you know. I know that 2 students of Professor Dr. von Heinig, Terry Gill from the Netherlands, a number of us went there, and we not only presented what we were finding, but we gave them our early drafts and allowed states to respond. The response was, and the ambassador was there, she was representing Finland, and in fact some countries sent large delegations. India sent 7 people on their delegation. China had 3 and so forth. It was a very frank discussion. It was a very sophisticated discussion. It was clear that states were very interested in having input to the process of law interpretation, and we were delighted. Some states, Finland is one of them, other states, United States, Canada, Israel, provided extensive written comments. Now, one country, I won't name it, one country on a single chapter, provided 83 comments. So we were excited that states were involved in this because we were trying to figure out what they believed the law to be. If they were to apply the law in a particular situation, how would they apply it? That was our objective, so we were delighted. Now, I will tell you, I expected it to be an enormous cat fight. I mean, you got the American delegation and the Chinese, and the Russians are over in the corner, and everyone else in between. I expected it to be an enormous cat fight between states, that there would be major differences of opinion. But in the environment of Chatham House rules, and with primarily legal advisors there, I found that there wasn't a lot of divergence. So if we were talking to a representative from China, for example, they sent a very, very talented attorney as the leader of their delegation, and I'm from Texas, just to place things in perspective. We didn't disagree on much. There was a little bit. I mean, how exactly does this apply? So when we got back the verbal and the written, what we found is if you're a lawyer from China, or if you're a lawyer from Germany or Turkey or Greece or Bolivia or Paraguay or Korea, you approach law in roughly the same way. You understand the same legal norms. So that made me very pleased because it gave me hope. My friend Kubo is one of the big thinkers in this field, has written some spectacular papers, has written the most critical paper on the Tallinn Manual, and it's a brilliant piece of work, published in the Israel Law Review. It gave me a lot of sense of optimism, these 3 meetings, because it told me that if we could move the politics out of the process, if we could do exactly what the ambassador said, quit thinking in zero-sum, thinking in win-win approaches, we could probably add a lot of granularity to the broad statements that have been made by states and UNGGE and NATO and so forth. So I was very optimistic about the process. What did we disagree on? There was a bit of disagreement on sovereignty with respect to the sovereignty of data. We promised non-attribution, so I will not identify the states. There was a bit of disagreement on that I don't know that we were able to resolve. When your data goes abroad, do you have sovereignty over data that's transferred abroad? There was some disagreement over non-state actors. Kubo mentioned non-state actors. I'm sort of a classic international lawyer. I think international law addresses states. It addresses conduct of non-state actors, but vis-a-vis states. However, there were views expressed that non-state actors are the subjects of international law, and they're obligated by international law and so forth. And then there were some discussions along the way, mostly in the margins, on this, what we were talking about on the break, the gap between Article 2.4 and Article 51 on the side, because one country in particular takes a different view. So in sidebar comments, we discussed those. But the ambassador was there. I think we would say if we were painting with a broad brush, we were painting with the same brush. It was when we got inside the lines, that's where we started, not Finland and Texas, but various countries started to disagree. So I'm very, very optimistic that if we can put politics to the side, we can move forward.
Thanks, Mike. I have one more question, and then I will give the floor to you, so please be prepared. This is a question for all of you, I think. What do you think should be, taking into account all these initiatives, the hard work of many years of Tallinn Manual and the UNGG, what would be the format for the next step? How do you take all of this and try to start to crystallize it into perhaps lawmaking, hard law? Maybe we can start from the other side.
Thank you. Within the UN auspices, I believe that the next GGE, which will begin its work in late August, in a matter of few weeks' time, I hope it will be able to identify more so-called norms for responsible state behavior. More specific rules, and in other areas than in a more diverse set of areas than so far, with a special emphasis on peacetime activities. But I wouldn't say that this result, even in the best case, would be a proper basis. It would not be a legal document, to put it briefly. The UNGGE is not a legal body, it's a political body, and it will try to create common understanding of what is needed. But should the UNGGE be successful, there might be an opportunity to bring a proposal for a legal instrument to a legal arena, such as the Sixth Committee of the UN General Assembly or another legal body. preferably at the UN, at the global level. It seems to me that the recognition of the need for recognized norms for state behavior has increased, and I hope this is well for the work of the GGE. But I wouldn't give an educated guess on when there would be negotiations on a binding document at the UN level on cyber activities.
I think I would answer that in 3 steps. So first of all, I think to some extent I provided an answer at the end of my presentation where I said in which order I think states should progress. Of course, so I think in the most immediate term it's really this greater forthcomingness, if you will, in pronouncing on matters of opinio juris. And in the second step, what is the appropriate forum? I agree with Marja that the UNGG seems to be quite an appropriate forum, but we should also keep in mind the criticism that has been leveled at this forum, that even though it contains the most active states in this area, it is still a forum of now 20 experts, now 25 in the new edition. So still not containing all of the actors in the area. And then finally, what is the content? I think that's the third step. So what should be the content of this? And we are seeing a measured overlap in the various initiatives. And there is a very good report by the East-West Institute from the end of last year, which attempted to identify these convergences. And so they include questions such as respect for sovereignty, which seems to be common to all of these initiatives, the emerging duty to cooperate in response to cyber incidents, and others. And so that would be my reply.
So I think it's a great question. I actually have an idea, and I think one state may be thinking along these lines. Of course, the reason we're doing the Tallinn manual is because we want to assist states. Many people in the group had been state legal advisors, like myself, at some point in their professional career, and we wanted to give state legal advisors a tool that they could refer to. We were very, 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 very careful not to do, for the lawyers in the audience, lex ferenda, what the law should be. We were trying to stick to what we believed the law to be. In that process, that 6-year process, we identified hundreds of points of law that were unsettled, unclear. So when you read the manual, you will see the international group of experts agreed this, we agreed that. However, on the issue of, for example, intrusion into a system in another country, the majority of experts believe that absent damage or whatever, this is not a violation of sovereignty. A minority felt it was a violation of sovereignty, and this is why. So one state has taken notice of this format and has, I believe, come to the conclusion that that's a pretty good starting point. And so I believe that what this state may be doing, and I encourage other states to maybe take on the initiative themselves, like Finland, what the idea is to convene not, the problem with the UNGG, I attended to play something with a lot of UNGG meetings. Politics keep getting in the way. I don't like you because you're this country, and so I'm going to, they think in zero-sum ways, but the lawyers, shockingly during the Hague process, did not. So the idea is take this Tallinn manual, where 20 world-class experts over a period of 6 years have identified fault lines in the law, lack of clarity in the law, and use that as the jumping off point, has the agenda, if you will, for a meeting of state legal advisors, and then produce a report. This would give you a sense of what those who are providing legal advice to the policymakers actually think about the law. Of course, you could not do attribution by states and all, but this would start to be a much more mature endeavor than the Tallinn manual, which after all is just 20 academics practitioners. So I hope the state does this, or that some other state picks this up, and that state legal advisor. So it's sort of a Hague process plus. We take it out of the hands of the non-state actors. The non-state actors act as advisors, but the states then take the initiative to begin to move forward, and then that can be fed into the UNGGE process. The problem with UNGG is I watch state legal advisors talking to their non-state non-legal counterparts who are, after all, in control of the process. It takes a long time to educate a diplomat or a military officer as to the nuances of the law. So I hate to say this, let's take them out of the room while we get our act together, and then we'll come back to them with the results of our work.
Thanks, Mike. Any questions in the audience?
Hi. I have this question for Kubo. That in your conclusions, you talked about the bilateral treaties. But that's too optimistic. There are only 3 treaties with the US, Russia, US, China, and China, Russia, which are not working or which are just for treaties or just for eyewash. So is it a positive step towards whatever your conclusion goes?
Yeah, so I agree with you, and I included that. That's why I'm saying that this is a step in the medium term. We are not there yet, but there are signs of hope. This is what I would argue. So if you then look in my paper, I include these references to the individual treaties. We see, one of those that I would highlight is in a high-level meeting between the United States President and the President of China in September 2015. A cyber arms control treaty was being discussed. So developments of this kind, if taken further, could then amount to this overcoming of this adversity towards treaty commitments in the future. But I agree with you, it will not happen tomorrow. So it's a long-term process or medium-term process. Thank you.
Hello, my name is Liis Vihol. I'm a senior analyst at the NATO CCD COE. I have 2 quick questions, one to Ambassador Lehto. Even though for the next year and a half, the next UNGG will be the primary forum for discussing international law matters, there are whispers that it's going to be the last GGE. So what are your predictions or ideas as to where the conversation might move after the next GGE? And in particular, what do you think of the idea that I believe some Russian diplomats have thrown in the air to give the topic to the UN 6th Committee? Do you have any ideas on that? And then a question to Dr. Maciak. You mentioned that in the long term, states should negotiate a cyber treaty. You must probably have thought of a special verification and compliance regime for such a treaty. And if you have, could you share your thoughts? Thanks.
Thank you very much. UN discussions on cyberspace and international law are of course not limited to GGE. There are discussions from other points of view in the second committee. There are discussions on privacy related to transboundary flow of information. And actually, for many governments, I believe, the issues of privacy have been much more relevant in recent years than the issues we have been discussing here, or the issues that have been discussed in Tallinn Manual. The GGE, this might be the last year or might not. And I must say it's a tall order to hope that after this 1 year negotiations or discussions in the GGE, there would be enough basis, a solid enough basis to begin legal negotiations. But should that be the case, in that event, I really hope that the work would be given to a legal body to be discussed between lawyers. And the UN 6th Committee has elaborated a number of international conventions. Another UN body, the International Law Commission, wouldn't exclude that either, but and a third opportunity would be a UN specialist agency. Of these 3, probably my choice would be the 6th Committee. Or then, should you have really a good draft and enough political will to go forward, you could also convene a separate diplomatic conference. But I don't think this will happen in 1 year. We would probably need more time, and you would need more patience.
And I think you would need a lot of patience to get to the answer to your second question. You know you're in trouble when Professor Schmidt sitting next to you tells you good luck in answering that question, which is what he whispered to me a moment ago. But I'll give it a try. The question was, what compliance mechanism would we think about, if we had this multilateral undertaking? So I'm going to say that the framework and the situation might change so much that it's very, very early to speculate about that today. But there are a number of models. So you can have an international treaty without a formal compliance mechanism. So hoping that the states will raise these issues in their mutual diplomatic interactions, and you know how that usually goes. Then you can think of an establishment of a soft monitoring body, or there could even be prospectively an international organization, a new institution. And I think all of those options would really be on the table if we get to that moment. But I think there is still a lot of work to do before we can get to the moment when we are talking about a comprehensive multilateral undertaking in the area of cybersecurity. And so I think it's something I'd like to discuss. I have an ongoing project with the university in Wuhan, Professor Zhijiang Huang, who would be known to CyCon attendees, and we are looking at divergences and convergences between the approaches to cybersecurity in the West and in China. And so this will definitely be on the table, the prospects for such a treaty. So we will certainly take this issue up there as well. But it's an excellent question. Thank you.
Okay, so I got the mic right now. So I have a question for Professor Schmidt, if I may. You mentioned some of the highly unqualified scholars and so on. And when we look back on a 1995 opinion on nuclear weapons, there was a kind of a strong position that when we talk about, well, technologically specific issues, states that have the technology should have a say. This was, I think, quite rightly refused as an argument, but didn't we come the full circle until now? I mean, we have states that use the cyber, know the cyber, and then we have this bunch of highly unqualified states. So what is their role in making the law?
So, of course, there's the principle of sovereign equality, which I know you're familiar with. All states are equal. Some states, unfortunately, are more equal than others. The interesting thing about cyberspace, there are states that aren't horribly qualified, and they're not particularly cyber-enabled or cyber-dependent. But in great part, most states around the world are either engaged in cyber operations as operators or as victims of cyber operations. So I will tell you that when we were, I only do international law, by the way. When we were dealing with international law, there was not necessarily a distinction between the legal aptitude of states that are super enabled in cyberspace and the legal aptitude of states that are not so super enabled. Good lawyer is a good lawyer, and they come in all sorts of they come with all sorts of passports. So I don't think it's a particular problem in this regard. Of course, there is the issue in terms of law of specially affected states, but I'm not sure there are any specially affected states in this particular area of the law. Listen, states are sovereign equal. All states, I mean, we've been talking about multilateral efforts to discern the law. States don't have to wait. States can step out now. So the United States is starting to do this. I commend my own nation. We're starting to put on the table what we believe the international law to be. Other states can do so, and if they put on the table bad ideas, they'll be rejected, because remember, pursuant to the Vienna Convention, you have to get agreement among the states. Pursuant to customary law, you have to have widespread state practice and opinio juris. So I don't see it as a particular problem. I'd be anxious, because if states started putting crazy proposals on the table as to what they believe the law to be, that would generate interest on the part of other states to clarify matters, which would then move the law forward, which is a positive development in my view.
guess I have the mic now. Ginny Griman, thank you all for your contributions. I've read most of your articles, and the Talon Manual, I learned the most from what was not in it and what was not covered, and that was very helpful because we make assumptions about what the law might be. So thank you for that great contribution. I'm a lawyer and a law professor who believes less law is better because then we're forced to come up with some practical resolution. And in that regard, I teach to various military groups, and they always want answers to questions that are impossible to answer. And I'm always asked, you know, well, what about the attacks on Estonia or the attacks on Georgia or the attack on, I'm one of the victims of the OPM, the personnel management system in the US, and the attacks on Sony. You know, when we look at how we responded, when I say we, those attacked, it always seems to default to the criminal law. And we make law by cases in the United States, common law. And if states continue to treat the attacks as a criminal attack, although we did have some sanctions issued after the Sony attack, we really won't be able to make law unless and until we treat the attack as an act of force and respond accordingly, either under the UN Charter or under the laws of armed conflict. So I'm curious what you think about the criminal responses as distinct from treating it as a cyber war, and whether you think, what are states waiting for? You know, we put out all kinds of responses in the media as to what we thought the attack really was and where it came from, attribution issues. So I'm curious, when do you think we will start to be able to formulate the law based on our actual responses and conduct? And if that does not happen, if we continue to respond in a criminal manner, then we may not be able to make law. So thank you very much for your time and your contribution.
Thank you. Let's take another question, and then I think we're running out of time already.
Tomasz Minarik, NATO CCD COE. I would like to ask all the panelists whether they see any potential for shaping of the customary law by the international courts. I mean, in particular, the two European courts, the European Court of Human Rights and the Court of Justice of the EU, which have been deciding some quite high-profile cases in the past few years, like invalidating the data retention directive or the safe harbor decision, or recognizing in the Zakharov case the conditions for state surveillance of the cyberspace. I know that these courts are regional, of course, but they are expounding or interpreting the law that is the same as, for example, in the ICCPR, and might have some influence on the interpretation of that as well. So what's your opinion on that?
If I may begin very briefly to the first question, I believe there's a problem if you cannot say that a certain attack originates from a state actor. Then it's very difficult to use the other areas of law. I would also like to thank the gentleman who posed the second question, because I believe the emerging jurisprudence of the European courts is quite relevant from the point of view of how the right to privacy should be understood in cyberspace. But since we are running out of time, as you reminded us, I will give the mic to Kuba, please.
Thank you. I will also answer very briefly. So to the first question, it is of course within the power and the prerogative of the states to respond using their domestic criminal law paradigm. But since we are looking at these incidents from the perspective of international law, I think it should be mentioned that cyber incidents might amount to a violation of international law, even if they do not cross the threshold of Article 2, Paragraph 4 of the UN Charter. So we may think of violations of principle of non-intervention, and then a step below interference with other states' sovereignty, and so those may also amount to violations of international law, and thus international law would be relevant. But then we get, as you rightly point out, to the question of attribution. So how do we trace these attacks back from a technical perspective? And in one of my papers I looked at the legal perspective. So the Article 8 of the ILC's draft articles would be very relevant, but we don't have enough time to go into the detail on the various standards that it offers. But happy to discuss it afterwards. And as for Tomáš's question, so I agree with Marja. I would say, yes, it is very, very interesting. And from the perspective of an international law positivist, which you are by now probably guessing that this is where I'm coming from, this may be persuasive, it may influence, but of course it does not dictate the international law as it is.
So let me deal with the first question on domestic and international law. I don't think the question is more law or less law. I think there's lots and lots and lots of law. The entire body of international law applies. The trick is to figure out how it applies. The problem is a lack of clarity. When there's a lack of clarity in the international arena, what happens is that states default to what they can do best, and they apply their domestic law. So let's take the Sony hack. The Sony hack caused a great deal of confusion. We were talking about use of force as an armed attack. The Sony hack is very, very easy. North Korea violated the sovereignty of the United States. As a result of that violation of sovereignty, they had committed what is known as an internationally wrongful act. Because they had committed an internationally wrongful act, the United States was entitled to respond pursuant to international law with what is known as a proportionate countermeasure. There are lots and lots of requirements on proportionate countermeasures, like notice and so forth. So my view is, as we get greater clarity on the international law piece, there's no reason not to resort to domestic law, but you won't be forced into a domestic law response. I believe you should be able to respond, and should respond, in fact, in both international and domestic law terms. Tomáš, so I'm tempted as a Texan to answer you. Europe has courts, but I won't, because I spend a lot of time in Europe. And Tomáš, I believe these courts are very, very important. And they're very important in the development of customary law. You must remember that there's international customary law, but there's an argument that there's regional customary law, and the decisions of the court, which are binding only on the parties before the court, the decisions of the court are influential in the development of European regional customary law. But beyond that, I couldn't agree more with my friend Kubo here on their influence. Even though they're influential, I mean, even though they're regional tribunals, nevertheless, they do have influence, and Article 38 of the statute tells us so, and we should be paying attention to this. It's very interesting, and I'll close with this. I had the honor of having lunch with, it's always good to name drop, Justice Sotomayor, who's one of the justices on our Supreme Court, a woman who I admire a great deal. I had lunch with her before I left the United States a couple of weeks ago, and I asked her this question. I asked her whether or not the United States should be paying attention as they render their decisions to the decisions of other courts in the world. And I said, I travel around the world and I get this sense that the rest of the world is frustrated because we Americans don't act like they exist when they render their opinions. She gave exactly the right answer. Kubo was channeling her. She said we should be considering them carefully, not as binding, but we should look at the logic of the court's decision in ascertaining what the law is. We can learn a lot from them. And so I could not agree with her more.
Thank you. Thank you for all your questions and attention. And I would like you now to give a round of applause for our great panelists.